Afternoon, good morning, dear viewers from wherever you're watching from. Here I am Kansonissima Gloria, your host for the Legal Matters show here on YPA TV every Tuesday at 9 a.m. So welcome back from the long break. I know we've not been around, I've not been around to shoot these good sessions with you to inform you about legal matters. However, I'm back and I thank you for viewing us. Please subscribe, please watch. You can share with your fellow friends, people who need some legal information free of charge. I won't charge even a penny. Yes, so last time, if I'm to do a recap, we're looking at interstate succession. We're looking at the different types of succession. I believe you now know the definition of succession, and maybe for those who aren't able to watch that previous episode, I'd encourage you to go on on our YouTube channel of YPA TV to see the episodes you missed last time. So for the previous episodes, we talked about succession and succession law. In other words, if someone dies, what happens if you die tomorrow? Are you ready for that death? Is your family going to be well catered for in case you die? So we are looking at that in summary. Of course, it's a broad topic and we cannot finish the whole topic at once. So in succession law, we looked at the different types of succession, and that's the tested succession and the intestate succession. Yes, one of our viewers asked a very brilliant question that what's tested succession? So the last time I was with you people, I explained in brief what tested succession is, and this is the succession where the deceased person's property is distributed where there is a will. Yes. So in case a person dies and they don't have a will, that's called intestate succession. Yes. Anyway, can we also look at what succession means? Succession refers to the process by which the property of a deceased person is inherited. It's the legal process of inheriting the deceased person's property and responsibilities. For example, when you die today, God forbid, of course, no person can come immediately and start claiming your property. You get. For example, if you died with a will, definitely people have to look at what you wrote in your will. Yes, the last time I also shared with you an example of the late Pope. Yes, the late Pope Francis. He himself, he had written a will of how he wanted to be buried. And you saw for yourselves, of course, some of you who went to Rome will be back. And the rest who are here, you were able to see on TV how they actually buried the late Pope. Yes, they put his wishes in action, because at the end of the day, by the time he writes the will, that's what he wants. Those are the wishes he expresses, how he should be buried. You know, most of the popes, like they were giving us the history, most of the popes were being buried in the St. Peter's Cathedral, I think, cathedral, or yes. So this time around, his wish was that he should be buried in another sacred place, which was in St. Peter's, or the St. Peter's Vatican Cathedral. Yes, so a will is very important. So if you're out there, you have your property, you don't know when you die, definitely I would encourage you to write down. You never know what that could help your children in the future. Instead of them trying to fight for this property, this one saying, no, they left for me this piece of land, they left for me this building. When it's written down on paper, it's very clear for them to identify, yes, the late left this and that for us in particular. So it's important to put these things on paper and get your lawyer to do what? To give you that legal advice of whether this is a valid will or not. Because remember, a will is a legal document that clearly says the deceased person's property, the deceased person's children, the people who are entitled to receive from this person's property. Not everyone, because you could be a dependent, let's say a distant uncle, and actually think that the deceased person left something for you. So in case you write your will, you also have to have that sort of legal knowledge. Don't just write a will anyhowly and think it's legally binding. For example, if you've brought in an executor and that executor is going to actually benefit from this will, ensure that they don't, one of those executors is not a witnessing person to that will, because they won't receive anything from your from what you've distributed. So the moment the person who is going to execute this will is mentioned or signed somewhere as a witness, believe me, they will not acquire or obtain anything that you have left for them to get. So make sure that some things that are, very essential, for example, signing of that will, someone may sign and then maybe they are coerced to sign, maybe they've not really given their consent to give out this property. Such a will is going to be considered invalid and it will not be considered in the courts of law. And if one of the members of the family brings it up as an issue or objects to this will in law, believe me, they're going to reject this will. So endeavor to see to it that the will is well written, it is dated, and it is signed. And of course, there has to be a witness to this. Yes, whichever will you write, you don't necessarily have to even give out property. For the case of the Pope, he didn't even give out any property, as you saw. He just wrote that this is where I want to be buried. Yes, so yes, that's really the brief I can give you on the tested succession. Let's take a break and we'll be back shortly. Welcome back, dear viewers, from that short break. Please keep it here on the legal matters. So as I was explaining the different types of succession, last time we looked at the tested succession, so today we're going to look at the intestate succession. So for intestate succession, what do I mean? Intestate succession, this is the legal process of distributing the deceased person's estate where they die without a will or a valid will. Remember, you may die, however, the will you've written is not valid and can be challenged in court. So if someone brings a will that has not been, which is not valid, of course, when it's challenged in the courts of law, you have to go by means of the intestate succession, whereby it can be declared that this person had no will at all. So I'm going to take you maybe through the legal process of how to actually distribute the deceased person's property where this person has died without a will. So when the deceased person dies without a will, first of all, the family has to sit down for a meeting, then decide who is going to be the administrator of the estate. You get? So not everyone can just become the administrator. Minutes have to be written down in a family meeting of who is going to take up the responsibility or the duty to actually execute or distribute this person's property. So what happens is, after the family meeting, then they decide who's going to be the administrator or administrators. Of course, it can't be one person, or it could be one person, depending. It could be one person or two. So when the administrator is appointed, then you have to go ahead and notify the administrator general. Yes, you have to notify the administrator general of the death of this person. So, and in some situations, there is where the person who has been appointed is a widow or widower of the deceased. So in this case, you don't need to get a certificate of no objection from the administrator's office. So if the person died and they were married, the wife or the husband, they could actually take up the duty of becoming an administrator. And in that case, they actually don't need the certificate of no objection. However, if it's in the case of a son or daughter of the deceased, or maybe an auntie or uncle, so in that case, that person has to actually apply for a certificate of no objection from the administrator general. So when they obtain this certificate of no objection, it has been granted by the administrator general. Of course, that's after reading the minutes of the family, and the administrator general is convinced that this person is appointed without any sort of coercion, or the family has consented to them being the administrators. So you go ahead and apply and file the petition for letters of administration in the courts of law. So this petition, it has to state the deceased person, the name of the deceased person who died. Of course, you have to attach some sort of evidence with this petition. For example, the death certificate. Remember, these people die, and then you have to bring proof of death. So that's when you have to present the death certificate. Then, of course, maybe you also present like the person's property, the property that this person that is going to be distributed. That may be titles of land. It might also be logbooks in case this person had a car or cars. So that evidence is all put on has to be attached on that petition that is filed in court. Then definitely the petition also has to mention the beneficiaries, and these are the children. So it has to clearly state who is going to benefit from this property. Then it also has to set the administrator, who is going to be the administrator of this property. So when all that information is put in the petition, it has to be filed in court. And definitely you have to file the petition with filing fees. Remember, you're a citizen of Uganda and you're supposed to pay taxes. So the filing fees or the court filing fees also have to come in, whereby you pay the fees. Yeah, so after the petition has been filed in court and it has been, of course, granted, yes, it has been filed, then a notice of petition for the letters of administration has to be advertised in the newspapers. It has to be a newspaper that is widely read, not a newspaper that is maybe Orumuli, that is in just one area code. So it has to be a newspaper that is read in so many different areas, yes. So when this notice is advertised in the newspapers, it has to be there for a period of 14 days from the date of advertisement. So for 14 days, you have to make sure that this advert is running. So if no one comes in to object to this petition for letters of administration, maybe a distant relative, then that's when court can go ahead and grant the letters of administration. However, if someone comes up and they say, no, I'm also a wife to this deceased person, or they're separate families, let's say the husband perhaps also got children in another person. So in that sort of instance, if someone brings such kind of a complaint to court that actually also my children have some rights in this property, they can go ahead and lodge a caveat on the grant of this petition. So immediately that caveat is brought in court. Definitely it has to be heard before they grant the letters of administration. And both parties have to bring in their evidence to show actually, no, this person didn't have any children outside, or a DNA is carried out, of course, in this case, to prove whether they are actually children outside, or whichever the case is, or someone claims to be a sister or brother to this deceased person and they claim to have also entitlement to the property. So in such kinds of instances, a caveat is lodged against this grant of letters of administration. However, in the case where there is no caveat or no one has come to object to this application, then court will go ahead and grant the letters of administration. So not so long ago, actually, there's been some sort of notice going around that if you applied for letters of administration before May of 2022, your letters of administration were going to expire. So hopefully, if you're out there and you applied for those letters of administration and they were granted before 2022, you went ahead and renewed those letters of administration. Otherwise, if it exceeded 30th of May and you didn't go ahead to renew, definitely now you're going to apply for fresh letters of administration, because the last administration letters of administration that you got expired and they will not be recognized in the courts of law. Yes, so if you're out there, that's just some little bit of advice to you who is out there and didn't know that you're supposed to have renewed your letters of administration. Yes, and also now when these letters of administration are granted, court has to put it to this administrator that they have to do what? To file an inventory within a period of 6 months. Of course, now when you have the authority, you can distribute the property in a way that the deceased would have wished the property to have been distributed. Definitely, your names are going to be on the land titles. Remember, if the person died and they are called Enoch William, and of course they died without any other person claiming this property, the administrator's name is the one which is going to appear on that person's on that person's title. So you have all the legal authority to transfer this property in whichever way you would have thought the deceased would have wished for you to distribute. So most of the cases, it's actually the widows or widowers that take up these letters of administration, because they would know best of how the spouse would have wanted that property to be distributed. So those are the key aspects that lie in the intestate succession. Yes, it's not like when someone dies, you just go and grab property in whichever way. Those were the ancient times. However, now the law says that if someone dies intestate, all those steps have to be taken so that property is distributed in a fair way among the family members. Remember the cases where in the ancient times where the person dies, let's say the husband of the lady dies and the relatives of the husband just come and grab, leaving the orphans in what? In dismay. So that's no longer the case. So if you don't go through all these steps, like I've mentioned them on how to acquire the deceased person's property where they've died without a will, then you're breaking the law. And in case that beneficiary brings you the courts of law, then you definitely have to pay the price. Definitely you'll be arrested and will be charged in the courts of law. Yes, so briefly that's what's entailed in the intestate succession. For example, if you didn't really understand the terms of how succession law operates, that's what I can state for now. And maybe next time, or if you need more legal information, you could reach out on our youth platform, social media platforms. Yes, Youth Platform Africa, social media platforms, and maybe come up and get some legal knowledge, because now this succession law also works in our case, because as you know, when you're a member out there or you're part of Youth Platform Africa, we always encourage you to come with a next of kin. Yes, so we can't maybe enter a contract with you without a next of kin, because as you know, life is not a guarantee. You just never know what could happen to you, Amos, tomorrow, or whoever. So that's why we encourage you to come with at least a next of kin, because of such case scenarios. In case something happens to you, who has the property rights to your property? Because you're entering a contract, yes, you're purchasing our products and our projects. So in case of something happening to you before the timeline of a contract ending, who is going to take up this property? So as you're aware, for us, we don't take in someone without a next of kin. Yes, in most cases. So that's also lies under succession law. So in case you're out there and you need more information, please reach out. Yes, and another thing I would want to inform you that at YPA we have new bundles that I wouldn't want you to miss out. And that is the Buzi combo, and as well as the Buzi Chabusi. So these are two different bundles that have been, YPA has given you people to, to try and benefit from our projects. So if you're out there and you want more information on these bundles, please reach out on my telephone number. I can give you more information on that, 0773 37 37 38. Please, thank you for being good viewers. I want to see you next time. Next time we shall be handling another different topic about the law. Please keep it here on the Legal Matters. Until next time, bye.